The Supreme Court has denied a stay that would have protected a state's Second Amendment sanctuary law. This law bars the state and its agents from enforcing federal laws which violate the Second Amendment. Despite the Supreme Court recently denying the law protections, the state here has not given up, so we need to talk about what's going on. But real quick before we jump into this video, if you think it's time for the Supreme Court to strike down more gun control laws, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated rows for organizations like FPC and GOA. So if you want great coffee and you want to support the two-way cause, check out Blackout Coffee using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, in this video, we're going to be talking about an order that was recently issued by the Supreme Court and essentially how it's impacting a state's Second Amendment sanctuary law. The recent Supreme Court order denied a stay which would have protected Missouri's Second Amendment Preservation Act. In 2021, Missouri passed a law, and essentially that was the Second Amendment Preservation Act. The law set the state's interpretation of the Second Amendment and set restrictions on the enforcement of inconsistent federal laws. The law prohibits Missouri and its officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent federal laws. The law uses the 10th Amendment as a basis to essentially refuse the state's resources that would then be used by federal agents or the federal government to infringe on Second Amendment rights. The law also created a civil remedy where anyone, any civilian, any just private citizen could sue a Missouri official if that Missouri official helped to enforce a federal law that violated the Second Amendment. Now, in response to this, the US government then sued Missouri. Recently, the Supreme Court got involved in this case and in fact denied a stay, which would have allowed this state here, Missouri, to continue to enforce this Second Amendment Preservation Act. However, the fight in this case is far from over because Missouri is already fast-tracking this case in the 8th Circuit, essentially, and they're trying to get this entire case dealt with and get the 8th Circuit to upend what the lower court said in this case. Now, in this case, the U.S. government sued Missouri under the theory that the law is unconstitutional because the statute is premised on an incorrect interpretation of the Second Amendment. Essentially, the government argued that Missouri's super pro-2A law is unconstitutional and the government's more limited interpretation of the Second Amendment is in fact correct. The government also argued that the summary language in the statute that Missouri put in it essentially made the rest of the statute language invalid, and that is why they argued the district court should overrule and reject this entire law. Now, the district court on review agreed with the US government and struck down the law in its entirety. The district court issued an injunction preventing the state of Missouri and its agents from enforcing the language in the statute. This Missouri law is essentially similar to the Texas abortion law and the recent Supreme Court decision in Whole Women's Health. If you aren't aware, the Texas abortion law, or SB 8, prohibits an abortion if a fetal heartbeat is present. This law is different from other laws because it's not enforced by the state, not enforced there by Texas or any of its executives, officers, agents, but rather it allows the individuals, private citizens, to sue any other individual who performs or knowingly aids and abets in that activity. This means that the enforcement mechanism is not the state itself, but instead it is the people who enforce the law. The enforcement mechanism of that law, again, is the people, and therefore it's a lot harder to get the law struck down in its entirety. This is because courts don't actually strike down laws. What they do is they place injunctions against the enforcement of a law. So for example, a court can enjoin the Missouri Attorney General from enforcing the law, and the result of that injunction is essentially the nullification of the law. If that state is barred from enforcing the law, then the law really has no effect. With the SB 8 scheme, however, you can't get this umbrella injunction against the state or its attorney general or its officers or agents, since they aren't actually the ones that are going to be enforcing the law. Instead, you can get an injunction against individual persons who are suing, but then someone else could pop up, again, bring a private civil suit, and then you can get an injunction against that person, and then another one could pop up, and then another one, and every time you would have to get an injunction, but you couldn't get an umbrella injunction against the state, really because, again, they are not the ones enforcing the law. Now, this SB 8 issue made its way to the Supreme Court in a case called the Whole Women's Health versus Jackson case. And despite what you hear, that case was not technically about the constitutionality of abortion. There was a different case, the Dobbs case, that really hit on that issue. But instead, the Whole Women's Health case dealt with the more procedural aspect and the whole structure of SB 8 and who could be sued, who can be enjoined, and then kind of how the lawsuits can proceed forward. This SBA case really dealt with a prior Supreme Court case called Ex parte Young. Ex parte Young dealt generally with the 11th Amendment, which stated that private citizens cannot sue the state or other officials because they have essentially sovereign immunity. However, a citizen can sue a state or its officials if they are violating civil rights. These are known as Section 1983 lawsuits. Under Ex parte Young, if an executive branch official is violating your constitutional rights or is threatening to, then you can seek a prospective injunction against them, i.e. a pre-enforcement challenge. The Supreme Court found that since SB 8 is not enforced by the state or its agents, then you cannot seek an injunction against them. You also, in that case, couldn't even get an injunction against the judges or the clerks who were involved in those lawsuits. Instead, you would have to get an injunction against each and every private citizen who brought that lawsuit. So that is kind of the backdrop and some of the information you would need to know for what the Supreme Court recently did in their order with the Missouri Second Amendment Preservation Act. Now, the district court, in reviewing this case and this statute, which again was challenged by the U.S. government, the district court on review struck down the entire Missouri law and enjoined the state of Missouri and its officials from enforcing that statute. Missouri then appealed the decision up to the 8th Circuit and also asked for a stay of the decision while the appeal is taking place. There was also an administrative stay that was in place, and so that was at least allowing the law to still be in effect. Now, on review, the 8th Circuit Court of Appeals actually denied a stay, and then that led Missouri to file an emergency application to the Supreme Court, asking for the Supreme Court to grant a stay and allow this law to remain in force and effect, at least until the appeal is taking place in the 8th Circuit. And recently, we got an order from the Supreme Court, an 8-1 decision, and that order states that the application for a stay presented to Justice Kavanaugh and by him referred to the court is denied. Justice Thomas would grant the application for stay. And then there was a statement from Justice Gorsuch and Justice Alito essentially saying that they are concurring, but then they added some additional language. And this is what they said. With the understanding that the district court prohibited only implementation and enforcement of HB 85 by the state of Missouri and its officers, agents, and employees, and any others in active concert with such individuals, I agree with the denial of the application for a stay under the present circumstances. An injunction purporting to bind private parties, not before the district court, or the challenge provisions themselves, however, would be inconsistent with the equitable powers of federal courts. There, they go on to cite Whole Women's Health for that language. Now, the goal was to get the Supreme Court to grant the stay, but only Justice Thomas was the one who was in favor of granting that stay in the favor of the state of Missouri, which isn't a shock because Justice Thomas is awesome and he's always consistent. Now, I will say that this was only a denial of a stay, which is an interlocutory posture, essentially. The Supreme Court does not like to get involved in these cases, especially when they're in these middle stages of litigation. But more importantly, what Justice Alito and Gorsuch said in the order with their additional language is essentially that the district court's injunction only applies to the state and its agents. It does not prevent private individuals from suing and still enforcing that statute. Now, even after this order, the state of Missouri by no means is giving up, and they've responded quickly. They have already filed for an expedited review in the 8th Circuit Court of Appeals, essentially saying that the Supreme Court has denied that stay and has changed the status quo of the laws in Missouri, and therefore the 8th Circuit here needs to review this case as fast as possible. They're asking for oral arguments to take place at the earliest possible time, and also the governments and their attorneys have not opposed the expedited arguments, so the likelihood is that the expedited arguments will be granted, and the likelihood is, I believe, that we will have oral arguments on this case in the 8th Circuit, probably before the end of this year. The hope is that on review in this case and the whole merits of this case, the 8th Circuit ultimately strikes down the lower court's decision. But regardless, this is going to be a critical case, and I think eventually this case is going to make its way back up to Supreme Court on a final merits review, and then it's going to be really interesting to see how the Supreme Court handles this and if they are even interested in reviewing this type of case. I will let you guys know if we get any more information on this case, and again, we'll definitely be keeping our eyes on it. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.